afternoon. You may be seated.
If it pleases the court, my name is Steve Smith, and I appear for the prosecution. Before I make my submissions, would Your Honour care for a summary of the case?
Proceed, Mr. Prosecutor.
In the folder before you concerns the issue of 5 young cats owned by Mr. Richard Dick, contained in a Target reusable shopping bag, found outside the charity clothing bin located outside the Salvation Army warehouse residing at 83 Research Road, Poraka. I would like to submit CCTV footage as evidence. This CCTV footage is aimed at the charity bins over a span of 24 hours each day. This footage clearly shows the face of the defendant at 5 a.m. and the unique bag the animals were contained in when found. Out of the 5 cats, only one was still alive upon discovery at 8:30 a.m. and was humanely euthanized due to blunt force trauma to the head and upper region of the abdomen, causing fractured cranium and eye sockets, internal hemorrhaging in the abdominal cavity, ruptured spleen, broken and fractured ribs. On April 19, 2018, Mr. John Hampton was found cruel to 5 animals of which he had no ownership over. The animals were beaten repeatedly with an iron bar found in the defendant's home, which caused pain and suffering that was unnecessary and unjustifiable.
What were the status of the other 4 cats, and how can you tell it was the iron bar that was used in the cruelty case, Mr. Prosecutor?
They were found dead with post-examination reports showing head trauma and blunt force trauma in the abdominal region, indicative to a blunt weapon like the iron bar used. Your Honour, we can determine that the weapon used was an iron bar, as upon investigation and discovery of the weapons, the iron bar was partially cleaned with traces of dried blood.
Christ. Prosecution may continue their submission.
Thank you, Your Honour. I will make my first submission on one count of ill treatment of one surviving cat that was found alive in the bag. Under the Animal Welfare Act 1985, Section 13, Subsection 1, under the definition of ill treatment as defined by Subsection 3, Part C, stating that a person ill-treats an animal if the person, not being the animal of which the person is the owner of, fails to take reasonable steps to mitigate harm suffered by the animal. The maximum penalty for this case, as stated by the Animal Welfare Act 1985, is either $50,000 or imprisonment for 4 years. We submit the following penalties due to the nature of these events. The surviving cat was suffering the before-mentioned injuries while being contained in the company of 4 dead cats in an enclosed space for 3.5 hours between 5 a.m. to discovery at 8:30 a.m. And by disposing the cat, he failed to mitigate the harm suffered by the animal. Furthermore, the prosecution requests that the defendant's own animals be seized and he be prohibited from owning pets for the duration of 12 months, and he be fined with $8,000 or be incarcerated for a period of 7 months, as was similarly sentenced in the Royal Society for the Prevention of Cruelty to Animals and Rogers case, and the Parker and Riley McDonald case. Your Honour, if I may summarize these cases' circumstances.
You have permission to recall the 2 cases.
Thank you, Your Honour. In the Royal Society for the Prevention of Cruelty to Animals and Rogers case, the animal in question mauled a child, and in precautionary measures, the owners decided to euthanize the animal via the method of bow and arrow, which left the dog suffering for a prolonged period of time before being seized by the RSPCA. The owners testified that they thought the animal had died from the arrow. The One Tree Hill magistrate charged the owners 2 counts of cruelty under 6 months imprisonment and to pay a penalty of $5,109.50. In the Parker and Riley McDonald case, Mr. Riley McDonald was cruel to 2 animals belonging to Miss Brumby. The cruelty resulted in injury to the cat and prolonged harm resulting in the death of the dog. The dog's body was then hidden inside a couch and abandoned elsewhere. The defendant was charged with 2 counts of cruelty under the Tasmanian Animal Welfare Act of 1993 and was sentenced to 9 months of imprisonment for acts against the dog and 3 months for the cat. If Your Honour has no question, I shall hand over the floor to the defence for their address.
Defendant, are you ready for your address?
Yes, and thank you, Your Honour. I am Smith Stevenson, Defence Counsellor for the defendant, Mr. John Hampton. but acting on behalf of Mr. Hampton, who is unavailable to attend this hearing, I'll establish that the submissions laid upon my client are without evidence and cannot be proven beyond a reasonable doubt. May I continue my case, Your Honour?
You may continue, Counsellor.
As my learned friend has stated, Mr. Hampton was seen by CCTV footage to have disposed of the bag containing animals. However, I would like to input that has not been witnessed that the defendant ill-treated animals, but simply was disposing of a bag from Mr. Dick. And nothing has shown that my client knew of the contents of the bag upon disposal. Secondly, I'd like to submit that it is only coincidence that the defendant had the identified iron bar inside their household at the time of the investigation. My learned friend has not been able to link this bar being used in the case without a reasonable doubt. There is only circumstantial evidence.
What does the defence think of the dried blood found on the iron bar in question?
That it cannot be proven beyond a reasonable doubt that the dried blood found in the iron bar belongs to the 5 cats. If that satisfies Your Honour, may I continue?
You may.
Thank you, Your Honour. My client gained no pleasure upon discovery of such an act and seems remorseful that he took part in such a scheme. Mr. Hampton has 2 dogs at home that are well cared for and in sound condition, and was simply trying to be a helpful friend in disposing of the bag, of which he now regrets being included in.
Thank you, defence. Do you have any inputs, Mr. Prosecutor?
I'd like to put forward that since one of the cats was found alive, that it would be unlikely that the defendant did not notice the suspicious nature of the bag he was meant to dispose of, as there would have been the smell of blood and the animals, but also a moving host, most likely audible cat inside the bag. A reasonable person would have noticed this.
Thank you, Mr. Prosecutor, for your input. Defence, do you have any further points you'd like to bring forward?
It's the defendant. He wants to talk to the defence.
Thank you, officer. I'll permit this and call a 15-minute recess to provide time for the defence and the defendant to discuss further actions, as we have time to do so this evening.
What do you mean you want to plead guilty now? Look, I don't recommend this. I really think... No. I really think it's in the best... The judge was just about to get us... No. Oh, fine. If that's what you want, even though it's against my professional opinion, we'll do that. We'll enter a guilty plea.
You may be seated. Defence, you may continue.
Thank you, Your Honour. The defendant has pleaded guilty to the prosecution's submission of 1 count of ill treatment of an animal. However, the defence admits that the defendant is not guilty of infringing the Animal Welfare Act 1985, Section 13, subsection 1, and has pleaded guilty to infringing the Animal Welfare Act Section 13, subsection 2, which has a maximum penalty of $20,000 and 2 years. Your Honour, my client had no intent in causing prolonged harm towards the 1 cat found alive, and therefore was unsuitable to be charged under Section 13, subsection 1, where intent must be proven.
Does the prosecution disagree?
Thank you, Your Honour. I have a few words. I would like to submit that the defendant, Mr. Hampton, has a criminal record mainly in relation to property offences, but also an assault offence, therefore showing that the defendant is capable of performing such ill treatments towards property and persons, no less an animal considered as privileged property.
Thank you. Without further input, I charge the defendant guilty of 1 count of ill treatment of an animal under the Animal Welfare Act 1985, Section 13, subsection 2, with 8 months imprisonment and the seizure of your current dogs to the RSPCA for rehoming, and a prohibition on owning pets for 2-year duration. You have a substantial criminal record, though mainly property offences. You have previously proven capable of assaults. While you have well cared for pets yourself and had your services requested by the owner in this instance, you have shown that alternate, more lenient punishments won't stop you from reoffending. You have given me no choice but to enact a prison sentence. Is the prosecution satisfied?
Yes, Your Honour.